Hello, everyone. Welcome to the U.S. Immigration News. This week marks a significant turning point in U.S. immigration policy. Whether you are inquiring on U.S. immigration as an employers, students, or individuals seeking work visas or green cards, this could be a critical week for you. Before President-elect Donald Trump takes office, there are many sweeping changes and new rules have been announced by USCIS that could affect the lives of millions of immigrants and the businesses that rely on them. Along with major updates to visa programs to discussions, we will look at the details on mass deportations and sanctuary laws. These developments highlight the ever-evolving landscape of immigration in America. If you are interested in this topic, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe, and like it, so that you may get updates straight to your smartphone. Now let's get into the video and look at them one by one. Number 1. Extended Work Authorization for EAD holders. In a move that has brought relief to thousands of non-citizens and their employers, DHS has announced an extension of the automatic work authorization renewal period for Employment Authorization Document EAD holders. Starting January 13, 2025, individuals with pending or timely filed EAD renewal applications will benefit from an automatic extension of up to 540 days, a significant increase from the previous 180-day period. This change is particularly impactful for industries that rely heavily on immigrant labor. Delays in EAD processing have historically left workers unable to continue their employment, causing disruption for both employees and businesses. The extended renewal period aims to address this gap, providing greater stability in the workplace. For EAD holders, this means fewer interruptions in their careers, while employers gain peace of mind, knowing they can retain their skilled workforce without the constant worry of authorization lapses. Number 2, rising concerns about deportations and travel bans. As the inauguration of President-elect Donald Trump approaches on January the 20th, 2025, concerns about potential travel bans and mass deportations are resurfacing. During Trump's previous administration, the introduction of travel bans caused widespread disruption, particularly for students and professionals from affected countries. Now, colleges and universities are advising foreign students to return to the U.S. before January 20th to avoid potential restrictions on their re-entry. The possibility of mass deportations has also raised alarm across the nation. Advocates for Dreamers, individuals who arrived in the U.S. as children under the Deferred Action for Childhood Arrivals (DACA) program, are preparing for potential legal challenges to their status. Meanwhile, local governments are debating whether to cooperate with federal enforcement efforts, with many cities reaffirming their commitment to sanctuary policies. These developments are creating an atmosphere of uncertainty for immigrant communities and employers alike. On the international front, some countries have issued strong responses to these potential actions. Honduras, for instance, has warned of diplomatic consequences if mass deportations proceed. This international pushback underscores the global stakes involved in U.S. immigration policies. Number 3, Visa Bulletin and Green Card backlogs. For immigrants navigating the green card process, the Department of State's January 2025 Visa Bulletin brings mixed news. The bulletin outlines final action dates and filing dates for various family and employment-based categories. While some categories have seen incremental progress, backlogs remain a persistent challenge, particularly for individuals from high-demand countries like India and China. The Bulletin serves as a crucial resource for immigrants and their attorneys, helping them determine eligibility for filing applications. However, the slow pace of progress in certain categories continues to frustrate many, highlighting the need for broader reforms to address these systemic delays. Number 4. Modernizing the H1B Visa program. The Department of Homeland Security, DHS, has introduced a groundbreaking final rule that will take effect on January 17, 2025, bringing substantial updates to the H1B visa program. For decades, this program has been a vital resource for businesses seeking highly skilled foreign workers to fill specialized roles. However, the new rule represents a paradigm shift in how this program will operate. Among the changes is a refined definition of what constitutes a specialty occupation. Employers will now face stricter criteria, requiring them to provide more substantial proof that a job qualifies under this designation. This adjustment aims to enhance the program's integrity by ensuring only genuine, high-skill positions are eligible. For international students on F1 visas, the transition to H1B status will be smoother, removing one of the long-standing hurdles they've faced when trying to secure employment after graduation. In another significant move, workers who have previously been approved for H1B visas will benefit from streamlined processing when changing employers or projects, reducing delays that have historically caused uncertainty. Entrepreneurs also stand to gain under the new rules, as they may qualify for H1B status if they hold a controlling interest in their organizations, an update that recognizes the growing role of startups in the U.S. economy. To enhance oversight, the rule codifies USCIS's authority to conduct inspections and introduces stricter requirements for aligning labor condition applications with H1B petitions. These measures underscore the government's commitment to curbing abuse while ensuring compliance. Employers are encouraged to adapt their hiring strategies to align with these new regulations and avoid costly penalties. Number 5. Changes to H2A and H2B visa programs. Temporary work programs are also undergoing significant revisions. The DHS has introduced updates to the H2A and H2B visa categories, which are primarily used for agricultural and non-agricultural seasonal work, respectively. These programs are indispensable for industries that face labor shortages during peak seasons. But the new rules aim to strike a balance between worker protections and employer flexibility. One of the critical changes includes a ban on certain fees charged to H2 workers. This measure addresses long-standing concerns about exploitation and ensures workers are not unfairly burdened. Whistleblower protections have also been extended, offering workers a safer avenue to report workplace violations without fear of retaliation. Additionally, employers will now be required to fully cooperate with compliance reviews, reinforcing the importance of transparency in the system. While these updates offer enhanced safeguards for workers, they also introduce new responsibilities for employers. Businesses must ensure their practices align with the updated requirements to maintain access to this critical labor pool. Number 6. H2B Visa Cap Reached. Implications for employers. USCIS recently announced that the cap for an additional 20,716 H2B visas for returning workers in the first half of the fiscal year has been reached. However, a separate allocation of 20,000 visas for workers from specific countries, including El Salvador, Guatemala, and Honduras, remains available. For employers relying on seasonal labor, This development underscores the high demand for H2B visas and the importance of early planning. Businesses unable to secure workers under this program may face challenges in meeting their labor needs, particularly in industries like hospitality and landscaping. Number 7. Sanctuary laws and enforcement tensions. As discussions about immigration enforcement intensify, sanctuary laws are emerging as a key battleground. These laws, which limit local cooperation with federal immigration enforcement, could complicate efforts to implement large-scale deportation policies. Advocates argue that sanctuary laws protect vulnerable communities and foster trust between immigrants and local authorities. However, critics contend that these laws hinder national security and public safety. The debate is likely to escalate in the coming months as the new administration seeks to assert its immigration agenda. The recent wave of immigration policy updates highlights the complexities of navigating the U.S. immigration system. From modernized visa programs to heightened enforcement measures, these changes will have profound implications for immigrants, employers, and the broader economy. As the nation braces for potential shifts under the incoming administration, staying informed and proactive will be key to successfully adapting to this new reality. Whether you're an H1B worker, an EAD holder, or someone pursuing a green card, understanding these developments is crucial for making informed decisions about your future. The U.S. Immigration News channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe channel for more U.S. immigration update videos.